very warm welcome to AKS, myself Rachna. In this session, we are going to continue to talk about the important bills and acts of 2019. I hope you are already familiar with the part 1 in which we have dealt about the three important bills and acts, and now we'll continue the saga in order to cover more bills and acts which are important for both prelims, mains as well as for group 1. Coming to the fourth bill, Interstate River Water Disputes Amendment Bill of 2019. Before we see the context of why they wanted to bring about the bill, first let us appreciate what are the provisions about this are given in the Constitution of India. Article 262 of the Constitution provides for the adjudication of interstate water disputes. This makes two provisions under this article. One is that Parliament may by law provide for the adjudication of any dispute or complaint with respect to use, distribution and control of waters of any interstate and river valleys. Coming to the second provision, the Parliament may also provide that neither the Supreme Court nor any other court is to exercise jurisdiction in respect to any such dispute or a complaint. So these were the provisions which were given in the Constitution. The main aim of providing such a type of Constitution is that so that there will be a successful functioning of the Indian federal system, because we know that a successful Indian federal system will depend not only on the harmonious relation and close cooperation between the center and the states, but also it requires the good relationship between the states also. That is the reason among many the Constitution of India has provided for adjudication of interstate water dispute. Because of these provisions, the Parliament has enacted two laws. One is the River Boards Act of 1956 and the second one is Interstate Water Dispute of 1956. Now the River Boards Act provides for the establishment of river boards for regulation as well as the development of interstate river and river valleys, right? So this river board is established by the central government on the request of the state governments concerned in order to advise them. Whereas coming to Interstate Water Dispute Act of 1956, this act empowers the central government to set up an ad hoc tribunal for the adjudication of a dispute between two or more states in relations to a water of an interstate river or river valley. And in this case, the decision of the tribunal would be binding on the parties of the dispute. So in this case, neither the Supreme Court nor any other court will have any jurisdiction in respect to any water dispute which may be referred to such tribunal under this act. So we have known under Article 262 there is a constitutional provision in order to set up such interstate water dispute, and likewise the Parliament has passed the Interstate Water Dispute Act of 1956, and we have seen all the provisions about this Interstate River Disputes Act. Now they have they're going to bring about an amendment to this act. Now let us see the context about why they want to bring amendment to this present act, so that the main aim of this bill is to streamline the adjudication of interstate river water disputes and make the present institutional architecture robust, right? It's 1956, it's a long way to go, almost like we have completed 60 to 70 years constituting this bill. So in order to streamline this interstate river water disputes, they are going to bring about the amendments, and now let us see the provisions of the amendments. The main objective of bringing about this bill, they say it is because the number of interstate water disputes are rising, and the main reason for such type of rising of interstate conflict is because of the demand for more water by the states. We know it's because of the increase in the population, more and more states are coming up with a more demand for the water, and this demand for water is rising, giving rise to the interstate water disputes, right? Although we have the Interstate River Water Disputes Act of 1956, which actually provides for the legal framework in order to address such disputes, but yet it suffers a lot of drawbacks which the bill wants to address. I told you earlier already this bill itself has become very old, and there is a need in order to streamline, in order to adjust with the current scenarios, right? The main drawbacks of this bill, if we can see, or act which was already existing, is that there is a lack of provision for fixing a time limit for adjudication, right? There is no limit as of today. We have never seen any kind of limit they have put, like present whatever the tribunal is put forward on a river, they have never given a time limit like you have to solve this case within 10 years or 6 years or 5 years. Such type of provision isn't there in the earlier act. Moreover, whosoever becomes the head of the tribunal, that present chairperson does not have an age limit. So maybe if the case is going on for around 30 years, that person will become the chairman. Usually the retired persons become the chairman for such type of tribunals. So there is a provision, maybe in his 90s also, still he may be the member or the chairman of the tribunal. So now they are seeking to amend this upper age limit for chairperson as well as the members of the tribunal, and they want to evolve a mechanism for the continuation of work, right? So if a chairperson or any of the member are not available or not working with the present tribunal, so during that time there was a provision that only the CJI should nominate such person. So until the CJI nominates, that position will be vacant, which is leading to the delay in the tribunal judgments. So this bill will seek to give what will they do in the time of any vacancy or a time limit for publishing the report also, right? So the main aim, I told you, they want to streamline the adjudication of such disputes and make the present legal and institutional architecture very robust so as to overcome the challenges that we have spoken here. So till now, irony is that if you have seen any kind of amendments that are being brought, it is either because of such type of discrepancy or some kind of injustice were there in that. So they wanted to bring the amendment so as to address it. But do you know why they want to bring this bill? It is only because of the legendary of time they have taken in order to give the judgment. Example, if you see, the Ravi Bias Water Dispute Tribunal has taken whole of 33 years in order to give the judgment, whereas the Kaveri Tribunal has taken 29 years, and others like Krishna, Narmada, Godavari, all of them have taken close to a decade or more, and as of yet today also many of them hasn't given their statement or the report yet. So the main aim is that in order to address the time that is being taken by these tribunals, once we put a time limit to them, they can start working a proper thing, right? So now the Ministry of Water Resource, River Development and Ganga Rejuvenation has identified the 5 causes for the delay. Remember what are the causes for the delay, so that the bill will seek to amend what are the provisions you can easily understand, right? So the first major cause they have rectified is that there is no strict time limit for education. As the central government keeps on extending the tenure of the tribunals indefinitely, even though in 1956 Act itself there it is given that they were to resolve the disputes within 5 years. Second one, there is no limit for publishing the report of the tribunal. If they are not, what is the reason that they have worked so many years if they cannot even actually publish the report, right? So that is actually taking away the main spirit of bringing or establishing a tribunal if the people do not have a report. Third thing, as I told, there is no upper limit for the retirement of chairperson or any other members. D. In case of any vacancy, the Chief Justice of India had to nominate a person who took time, and this again caused a considerable delay. And again, the very important thing here is that there is continuous absence of data on the river basins. Then if some tribunal was established in order to talk about a river, what is the main aim? If there is no data at all about the river basins, how will the tribunal decide? So, in order to address these 5 causes which were rectified by the Ministry of Water Resource River Development and Ganga Rejuvenation, they have brought about this bill. So, this bill is going to provide a two-tier resolution mechanism. Remember, earlier there was only one establishment of each tribunal for each case, but now they have brought about a two-tier resolution mechanism. This bill will provide for first one called as dispute resolution committee. First, they will establish a dispute resolution committee which will be headed by the secretary level officer of the central government. Secretary level means some IAS person will head this dispute resolution committee, right? And but remember that here a secretary level committee should be an expert from the relevant field, right? So now if this dispute resolution committee fails, then the dispute will go to the centralized single standing tribunal. But there will be many kind of cases coming up in front of the tribunal. So that is the reason they have going to establish one centralized tribunal, but yet it will have multiple number of benches instead of a multiple tribunals that are existing now. So with the setting up of these tribunals, all the existing tribunals would be dissolved and the pending cases before these tribunals will be transferred to this tribunal, and the decision of the tribunal would be final, binding on the states, and have the same force as an order of a Supreme Court. However, if at all, if the matter of dispute is still persisting, then the matter could be referred back to the same tribunal, and the decision of the tribunal can sometimes be challenged before the Supreme Court through special leave petition, right? So first it will go to the dispute resolution committee, then it will go to the centralized single standing tribunal, and if at all, if there is a problem with the judgment that was given by them, they can ask to be reconsidered, and after reconsideration also, sometimes they can even challenge in the Supreme Court through a special leave petition. So coming to the composition of the tribunal, this tribunal will have one chairman as well as one vice chairman with 6 members. See here, the 6 members, within the 6 members, 3 members will be specialized from the judiciary, whereas the other 3 will be experts. All these 6 people will be appointed by the central government through a select committee, and this select committee will consist of Prime Minister, CJI, Minister of Law and Justice, as well as Minister of Jal Shakti. And not only this, central government does not only appoint these members, 6 members, but also it will appoint 2 other members called as assessors. And basically these assessors will be from Central Water Engineering Service, and of the chief engineer rank, the 2 other experts called as assessors will be appointed. Kindly revise again. First, there will be one chairman as well as the one vice chairman along with 6 members. In 6 members, 3 will be judiciary, 3 will be from the experts, and all of them will be appointed by the central government through a select committee, and this select committee will consist of Prime Minister, CJI, Ministry of Law and Justice, as well as Ministry of Jal Shakti. Along with the 6 people, they will also put forward 2 other persons called as assessors, who will be serving as a chief engineer rank in the Central Water Engineering Service, right? So now coming to the age of the chairman, as I told, earlier Act did not provide for the age limit of a chairman. Now they have said that it will be either 5 years or 70 years, whichever is earlier. That will be the time limit for the chairman as well as vice chairman. Coming to the members, they have to retire by the age of 67 years. So coming to the next flaw that we have seen in our previous act, that is, they have never provided a time limit for a tribunal in order to give its report, right? So now they say that the maximum time that will be given to the dispute resolution committee is 1.5 years. So within 1.5 years from the time they have filed the case in front of the dispute resolution committee, they have to give the judgment. And if at all whatever has been given by the dispute resolution system, if the person is not satisfied, then he can approach the centralized tribunal, and this centralized tribunal will have altogether 3 years. And if at all the states are still not happy with the judgment, they can ask the tribunal for reconsideration, and during this reconsideration period should not take more than 1.5 years. So on the whole, in total it is 6 years by which a tribunal must give the judgment. But yet the another major flaw that we have seen in the act was that these tribunals were not giving the report. In this act also, they have never mentioned that there would be no requirement of the publication of the tribune's report. Then actually this is wrong. Actually the law bill or should be made compulsory, so that this tribunal, once it gives report, it can act as an anchor for any kind of interstate disputes which are arising. But yet this bill does not provide such type of provision in order to publish the report about the tribunal. So another major flaw that we have seen is that this particular tribunals does not have a data about the basin wise, right? So now this bill is seeking to provide for a transparent data collection system at the both national level for each river basin, so that the lack of which has been felt for really long time, as we have seen. So the 5 flaws that we have seen in the present act will be fixed by this bill, and maybe sooner or later this bill will become an act. As of yet it is not passed by the Lok Sabha, neither the Raj Sabha. It is just introduced in the Lok Sabha. Coming to the next most important yet very controversial, the Jammu and Kashmir Reorganization Act of 2019. So coming to the Constitution of India, if we see about the state of Jammu and Kashmir earlier, it was guided by 2 articles. First is about the Article 1, which speaks about the state of Jammu and Kashmir to be the constituent state of Indian Union. On the other hand, Article 370 of the Part 21 of the Constitution, it grants a special status to the Jammu and Kashmir. So accordingly, all the provisions of the Constitution of India do not apply to the state of Jammu and Kashmir, and it was the only state in the territory of India to which all the provisions of Constitution of India did not apply, and it was the only state to have a separate state constitution as well as a separate flag, right? So all these provisions were given to the Jammu and Kashmir. Seeing his history, we know that on August 15th, 1947, all the Jammu and Kashmir became independent just like India. They never wanted to join the Indian side, but yet the Maharaja of Hari Singh had signed the instrument of accession after seeing the aggression which was done by the Azad Kashmir forces, which was supported by the Pakistan. So once this instrument of accession was signed on 26 October 1947, if you remember, I'm here talking about the 26 October 1947. So from 1947 to up till 1950, before they came Constitution of India into the proceedings, we Indians were in the dominion status, right? So this under this system, the state surrendered only 3 subjects to the India, one being the defense, and other being the external affairs, and the third one being the communication, and rest all were kept only with the Jammu and Kashmir, right? So in this provision, the power of the parliament to make laws for the state was very, very limited. Only those matters of union list and concurrent list which corresponds to the matters which were specified in the state's instrument of accession, only on such type of laws they could make the law in the parliament, right? So this instrument of accession contained a lot of matters like classified matters under 4 heads. First one being external affairs, defense, as well as communication, and the ancillary matters, right? So these were the provisions earlier. There were a lot of provisions which are totally different to that of the Constitution of India which were given to the Jammu and Kashmir, including the Schedule 6, the tribes, is not applicable to the Jammu and Kashmir, right? So now this bill is going to reorganize the state of Jammu and Kashmir into two parts, namely Union Territory of Jammu and Kashmir with legislature, just like now we have of Delhi and Puducherry. Both are union territories, but yet they have a legislature. But the Union Territory of Ladakh will not have any kind of legislature. It will work like any other normal union territories. Now, this Union Territory of Ladakh will comprise of Kargil as well as Leh districts, and the Union Territory of Jammu and Kashmir will have the remaining territories of the existing state of Jammu and Kashmir. So once we know a state, when it becomes the Union Territory, it is no more the governor who works over there, but it is the lieutenant governor. So here also the Union Territory of Jammu and Kashmir will be administered by the president through an administrator appointed by him known as lieutenant governor, and the Union Territory of Ladakh will have the same provision, which also will be guided by the lieutenant governor who will be appointed by the president in order to administer. So coming to the Jammu and Kashmir, where it will have a legislature, although it will become a union territory with legislature, right? So this bill envisages total number of 107 seats to the Jammu and Kashmir, but yet 24 seats has been left vacant for the region called as Pakistan occupied region. We know that that is our territory, but illegally Pakistan has occupied it. So we are leaving that 24 numbers as a vacant seat. So now as of today, the Jammu and Kashmir will have only 73 seats, right? So this assembly, just like any other assembly, will work for a term of 5 years, and the lieutenant governor may summon the assembly at least once in 6 months. So this particular legislative assembly can make laws for any part of the Union Territory of Jammu and Kashmir which are related to the any matters specified in the state list of the constitution, except police and public order. Remember, any matter in the concurrent list applicable to the Union territories. Further, Parliament will have the power to make laws relation to the matters for the Union Territory of Jammu and Kashmir, right? So all the police and public order come under the state list, but yet this has been reserved by the Parliament itself. So coming to the Council of Ministers, the Union Territory of Jammu and Kashmir will have a Council of Ministers, right? Because it is having the legislature just like Delhi and Puducherry. So it will have the Council of Ministers. Just like in the Parliament, not more than 10% of the total number of members can become the Council of Ministers in the Assembly. Now this council will aid and advise the Lieutenant Governor on matters that the Assembly has powers to make laws, right? And all this will be communicated by the Chief Minister to the Lieutenant Governor. Coming to the High Court, that is justice system of a state, there will be a common High Court for Jammu and Kashmir as well as the Union Territory of Ladakh. Coming to the next very small yet important bill called as Supreme Court Number of Judges Bill. So this particular bill has an intention in order to change the numbers of the judges who are presently working in the Supreme Court. The main aim of this bill is to increase the strength of Supreme Court judges by 10%. As of today, if we see, there are only 30 persons excluding the CJI, so there are 31 persons who are working now, and because we are taking into consideration only 30, they want to increase the 30%, that is 3 members, to the present strength of the Supreme Court. So as of now, it is fully 31 people including the CJI. So once this bill actually becomes an act, so it is going to become 34, right, including the CJI. So the main purpose of increasing the number is that obviously we know there are a lot of cases that are coming up before the Supreme Court, and if we see that Supreme Court has had a very novel beginning with just 4 to 5 judges, and because of the coming of cases and lot of pending, they kept on increasing the number of judges. And earlier this 5-6 judges used to sit together and solve the cases. Then they felt that such type of cases are leading to the pending. They have themselves divided them into a lot of benches so as to solve the cases more readily. Now this particular bill is going to make the strength to 34, right? So the purpose, if we see that, it is to allow the Supreme Court to function more efficiently as well as effectively towards attaining the ultimate goal of rendering speedy justice to the litigants. So the more the number of judges, the more speedy trial it will come, right? With this intention, they have introduced in the parliament. So here the important thing to remember is that increasing of number of judges is in the hands of parliament. Coming to the next important bill, most talked, most controversial, still in news, is the Citizenship Amendment Act. Although we will not go dive into how far it is correct or how far what are the protects and what are the other things which are related to this act and all, we'll just discuss about the provisions that are given in the Citizenship Amendment Act. This act will make the illegal migrants who are Hindus, Sikhs, Buddhists, the Jains, Parsis, and as well as Christians, all the 6 members who are coming from the 3 countries, namely Afghanistan, Pakistan, and Bangladesh, who acquired the citizenship, right? So also remember what are the exemptions which are given in this act. One is that they're going to exempt certain areas in the northeast from this provision, and this bill also seeks to amend the provisions relating to the overseas citizen of India card holders, right? So who are this overseas citizen of India card holders? Is like any foreigner who may register as OCI, that is Overseas Citizen of India under Act 1955, if they belong to the Indian origin. What do you mean by this Indian origin is that the particular person must be a foreign citizen of India. In this case, we can remember our Akshay Kumar, right? We have seen the controversy that he holds a Canadian passport. So he is not anymore the citizen of India. He was just a former citizen of India, or his children can acquire this kind of overseas citizenship card holder. Or if even Twinkle Khanna can apply for the overseas citizen of India because she is a spouse of Akshay Khanna, right? So this they want to amend this Overseas Citizenship of India Act of 1955. Coming to the key features of the bill, this bill, I'm again and again saying bill, but it has become an act. So just because the provisions here are taken when it was introduced during the bill, I'm mentioning it as bill. Okay, right. So this present act will adds 2 additional provisions on the citizenship, especially to the illegal migrants who are coming belonging to the 6 religions as we have seen and from the 3 countries. One is that they will be entitled rights such as to travel in India and to work as well as study in the country, and this bill seeks to amend the act to allow the cancellation of OCI registration if a particular person has violated any law notified by the central government. So coming to the consequences of acquiring the citizenship, right? So this act says that on acquiring the citizenship, such persons shall be deemed to be citizens of India from the date of entry into the India, right? If you remember the date here, they are mentioning to 31st December of 2014. From then, whosoever has entered into India, now they will be called as citizens because it's already 2019 now. So it's 5 years from when they have been residing in India, so they can become the citizens of India. And second thing is that all the legal proceedings against them in respect of illegal migration or citizenship will be closed with the coming of this act. Coming to the exception, this is more important because inclusion we have been listening so much, so we will tend to remember, but try to concentrate on the exception also, right? The bill here acts for the provisions on citizenship for illegal migrants. As I told, it will not apply to the 6 scheduled areas of the constitution, namely to the tribal areas of Assam, Meghalaya, Mizoram, as well as Tripura, and the tribal areas included in the Karbi Angolan in Assam, Garo Hills in Meghalaya, Chakma district in Mizoram, and tribal Tripura tribal area districts. They all will be exempted from such type of Citizenship Amendment Act. As well, this particular bill will not apply to the areas under inner line under the Bengal Eastern Frontier Regulation of 1873, as well as inner line permit regulates visits of Indians to Arunachal Pradesh, Mizoram and Nagaland. The bill further reduces the period of naturalization for such group of people from 6 to 5 years. Remember this. Next important bill, that is merger of Dadra and Nagar Haveli and Daman and Diu, both of these union territories. Before we can appreciate about the bill, first let us see what are the constitutional provisions available which will authorize the parliament for such type of provision, that is here in this case they are going to merge the two union territories, right? So parliament powers to reorganize the states, if we can see under Article 3, the parliament is authorized to form a new state by separation of a territory from any state, or by uniting two or more states or parts of the state, or by uniting any territory to the part of any state, right? Remember this. As well, this particular article actually has more kind of B, C, D and E. Like in B we can see increase the area of a state, or C is to diminish the area of a state, D is to alter the boundaries of any state, and E is the altering the name of any state, right? So however, this parliament, although it is authorized to do or form a new state, but this article has laid down two conditions in this regard. The first one is that any parliament can introduce a bill only after taking the prior consent of the president. And second condition is that before recommending the bill, the president itself has to refer the same bill to the state legislature concerned for expressing their views within a specified period. So these were the two conditions which were laid down in the Article 3. First is that any bill can be introduced in the parliament only on the recommendation of the president, and president can actually make such recommendation only after sending such type of bill to the state legislature for the consideration within a time period. But yet if you can see, the president here is not bound by the views of the state legislature. Then why are you asking the state legislature, right, if they are not bound to by the views what is expressed in the state legislature? But yet because India is more of unitary form, right, that is the reason maybe they have given this provision. Just it is very symbolic of the president in order to ask the bill to be considered in the state legislature, right? So because the president, neither the parliament is bound by the views of the state legislation, and they may accept or either reject them even if the views are received within time, right? So further, remember that it is not necessary to make fresh reference to the state legislature every time an amendment to the bill is moved and accepted in the parliament, right? If the bill here was having some one or two provisions, but yet after the state legislation has given its views, if parliament has brought about another kind of amendment, now when bringing such type of amendment, every time the president need not actually take the view of the state legislature. Obviously first view itself is useless. The state does not have any say. So in the next amendments also they did not say anything about this bill. But important thing to remember is that here president is referring to the state legislature only because only the states have state legislatures, right? But in case of union territories, there is no provision of such type of legislatures. Example, if there are only two legislature of UTs, one is Delhi and other is Puducherry, right? In this case also, because there are union territories, the president here may not refer the bill to the union territories or to the union territories with legislature, right? So here directly any parliament can introduce a bill with the recommendation of the president. Only first condition is applicable over here. So in the merger of union territory of Dadra and Nagar Haveli and Daman and Diu, it is a direct provision on the recommendation of the president this bill was introduced in the parliament, it was not at all referred to any of the union territories. So, in other words, we can say that Parliament can redraw the political map of India according to its will, and hence territorial integrity or continued existence of any state is not guaranteed by the constitution, right? That's why they say that India is described as indestructible union of destructible states, right? The irony here is the same. So now coming to the key features of the bill, here it includes that the first schedule of the constitution specified the territories that come under various states and union territories. So remember that whatever the bill has been introduced in the parliament, it just needs a simple majority to pass it, right? So simple majority is damn more easy, isn't it? So now coming, the bill amends the first schedule to merge the union territories of two union territories, namely Dadra and Nagar Haveli and Daman and Diu, and the merged territory will form a union territory of Dadra and Nagar Haveli and Daman and Diu, and this will come into effect from the day notified by the central government.